hopefully, maybe. Okay, we're good to go. So tonight's topic, rules and regulations. And sometimes we throw in resolutions as part of that sort of category of governing documents. And one of the big takeaways for any rule, and by rule, I mean, generally speaking, something that is adopted by the board of directors, that the board has authority to do, that usually does not require a vote of the owners. And one of the biggest requirements for any rule is reasonableness. Now, I'm going to show you a quote. Now, Bruce doesn't know this, but when he was in law school, he did his capstone, like his thesis paper on board of directors' authority to adopt rules and regulations.
You're saying I don't know that I did that?
No. What I'm about to say is you left a book here that you use and all of your margin notes. So on the first page chapter, it says if a rule is reasonable, the association cannot adopt it. If not, can adopt. If not, it cannot. And that's from Hidden Harbor. I'm not sure. I think that's Florida, but Bruce, I think you wrote off to the side. This is too broad of a principle for you.
It is.
Why?
Because it's just saying that a rule might be reasonable. That doesn't necessarily mean the board has the authority to adopt it.
Touche. Now, before we dive into some of the other stuff, one of my biggest pet peeves is boards or even their lawyers who draft rules with legalese in such a way that owners can't even understand what the rule is trying to accomplish. I'm going to give you an example. What I'm about to show you is the actual text of a board of directors resolution. Be it further resolved, if proof of insurance is not provided within 30 days, and now granted they spelled out 30 plus put the number, as required above, the association notify the unit owners they are in violation of this resolution, and after hearing an opportunity to be heard, will be subject to a fine in the amount of $50 per month, which will increase to $75 for 60 days, 100 for 9. Someone quickly, in one sentence, tell me what this is. I mean, you can get it, but it's very difficult to understand and digest. Now, look at this. This is the same thing written in plain English. Owners must provide proof of insurance within 30 days. After notice of the violation and an opportunity for hearing, the association may fine owners who do not provide proof of insurance. The initial fine is $50. After every 30-day period, the fine will increase by 20. Isn't that much easier to understand and digest than this?
Yeah, without a doubt.
Now, it takes intellectual horsepower and work to do this kind of thing, but I think it's important enough that the effort needs to be done to make sure that the rules are written in plain English. There's a legal writing professor at the University of Texas, and I used to go to his seminars every year. And the governor of the state of Texas appointed him to rewrite all of the real estate and consumer contracts used in Texas. And because the governor said, listen, a lot of these documents that folks are signing on to and agreeing to abide by, most, unless they have a law degree, don't even understand what it means. And so there needs to be an effort to convey things in plain English that people can understand. All right, now, for the rest of the hour, we'll talk for a little bit about governing documents, types of rules, enforcement of rules, and I'll also show you several samples, some good, some bad. And we'll also do, I'm bringing them back, a couple of polls. And actually, let's do our first one. Disregard this second piece. So here's the question, and hopefully that popped up on your screen. Suppose the CC&Rs are silent about parking, or they don't say anything about parking, and the board decides they want to adopt a rule prohibiting inoperable vehicles. Can they do that? Check yes or no. We'll get some live. One says yes. So far, everyone's saying
You're going to
yes.
have to answer both questions before you hit submit.
Oh, thank you. Yeah, I messed this up and didn't delete this thing under here. My bad. But it looks like the bulk of people are saying yes. Bruce, what do you think?
So this was actually a question that I had this was kind of the question that made me write my capstone paper about this topic in law school. Because we used to represent, or you used to represent, Kevin, a big HOA down in Lapine,
Yeah,
you recall?
yes, I do.
And they didn't have anything in their CCNRs really about it, much restrictions, but they were really upset about there being sort of cars on blocks in people's lawns all over the place. And there was a lot of questions about whether the board could adopt a rule prohibiting that without amending the CCNRs. And ultimately, I came down on the side of yes, but I think it's an open-ended question a little bit. And the reason we'll get to it is I think that it is probably within the scope of the general authority that is conveyed under ORS 94. And I can go into that in great detail, but we have other slides about that coming up, so I'll explain it a little bit more later.
Good. Now, in terms of when I use this phrase governing documents, generally I'm referring to the CCNRs, the declaration, plat, bylaws.
Kevin, you should take the poll down.
Oh, I thought I did. Let me stop that. Relaunch download. Okay, let me close that. Did that take it away?
No, I still see it.
I see it.
You see it still?
Yeah,
Let's see here.
It's gone for me.
Oh, it is.
not for me.
Try just closing it, Bruce. Can you just close? I ended
On
it.
my own screen? Oh,
Yeah.
I can, as you have to close on your own screen.
Oh, there you go. Okay. Bylaws, and then at the very bottom, and this is kind of in a hierarchy, and actually, arguably plat, Bruce, our position is generally a plat. If there's a discrepancy between the plat and CCNRs, plat generally prevails.
It's a tough question to answer. I
Yeah.
actually haven't really seen a case where there's been a big discrepancy between CCNRs and the plat, so I don't know how often that's really relevant, but I would argue that the plat would prevail.
Yeah. Now, in terms of federal and state law, it completely depends on what law we're talking about. Often in the statutes that govern your communities, they frequently start out saying, unless your governing documents provide otherwise, then this. So oftentimes your governing documents prevail over something, the default provision, so to speak, in the statute. And then there's a handful of federal laws that apply. There's the Federal Flag Act, which prohibits you from adopting a rule that says owners cannot display the American flag. There's the Over-the-Air Reception Device Act, which says you cannot create rules or regulations that prohibit owners and homeowners associations from installing satellite dishes. And there's others. We'll talk about a couple of others as we go. Now, the characteristics rules. Back to this hierarchy, though. Which of these documents are recorded in the county recorder's office, and therefore, when an owner buys in, gets a copy from the title company?
CCNRs.
Yep.
Bylaws.
Bylaws, almost always bylaws. There's some older associations that predate the recording of bylaws requirement, but in general, yes. And then the plat. And why do I bring that up? So how do owners know about rules and regulations if they're not recorded and they don't get them from the title company when they purchase? And I did not mean for that to be a hypothetical. I was hoping. No, you have to make sure that the owners get it somehow. Now, a lot of associations have welcome packets for new owners that have all of the board's resolutions and unrecorded rules and regulations. When you adopt a new rule, you need to distribute that rule to all owners before it can take effect and before you can enforce it. So keep that in mind. When owners move in, they don't have the rules and regulations until you give it to them. Now, as far as characteristics of rules, I said earlier, generally speaking, the board without owner vote or approval can adopt rules. Catherine Garrell, are you here? I thought I saw you sign on. Maybe not. Catherine, are you there?
Can you hear me?
Yes, hi.
Hi, yes.
Sorry for putting you on the spot. I was just going to share, what do your bylaws say about rules and regulations?
The bylaws?
Or the CCNRs, actually, sorry.
Oh, let's see. It's been a while since I've
I
read,
know, but and
and
now,
you did it. But basically, it syncs up obviously with the ORS 94, which
yeah.
says that in order the association is empowered to create rules and regulations as part of their management of the operation.
But we did something in addition to that, which we said a vote of 30% of the owners. Right, that's what I'm
Don't
going.
ever do that. Yeah.
Hey, that was, that was not my idea.
I know it, but I'm telling everybody, don't do
Yeah.
that. Learn from my mistakes.
um, yeah. So when I keep saying that, yes, boards adopt, but there could be, it's possible your documents say something else, but that's rare and that's a minority. But in general, yes, the board can adopt that without approval from the owners. Now, back to this hierarchy. Nothing in the rules can be in conflict with any of these things above it. So you couldn't have a rule that says the quorum requirement for annual meetings is 10% if your bylaws say 20%. Okay. Now here's one. What if there's a conflict between your bylaws and your declaration CC&Rs? Which one prevails?
CC&Rs.
Yeah, CC&Rs are going to prevail. All right, now categories of rules. There's lots of categories. I generally lump them into one of these. Kind of use, common areas, common elements, lots, units, that sort of things. What you can and can't do on common property, maybe in a condo, what you can and can't do in your unit. Architectural, aesthetic rules, and behavioral types of rules, okay? Now, here's the general criteria. Bruce, I'm going to turn it back over to you to kind of discuss particularly the reasonable piece, but the rest of these as well.
Oh, really?
Is that okay? Please.
Fine. Well, yeah, so generally speaking, rules have to be applied equally. So relate to the operation purpose of the community. Generally speaking, that's correct in the sense that, they have to be within the board's authority, and the board's authority is probably going to be focused on the general purpose of the association. But I'll get more into that when we get into scope of authority. Reasonableness is tricky, right? Reasonable is somewhat in the eye of the beholder. And my take is that as long as there's a reasoned purpose behind it, sort of a logical reasoning to it, that the reasonableness of a rule is a court would find a rule reasonable. I think if a rule comes across as overly oppressive, intended in some way to treat owners unequally or something along those lines, the court might find it unreasonable. But I haven't really seen any cases where a rule is, is disqualified by a court simply on the grounds of it being an unreasonable rule.
Let me ask this. Is it reasonable for a board of an HOA to adopt a rule that says no mountain lions or cougars anywhere on any owner's lot?
Well, you're talking about the Turdick case, yes? Turdick v. Stevens?
Uh-huh.
That's not exactly what the board adopted in that case, but in any case, is it reasonable? Probably it's reasonable, yes. Is it within their authority? It depends.
What was the outcome of that case?
That wasn't the rule. So basically what had happened was the owner in that case built a cage outside to house their cougars. And the board said, you didn't really have architectural approval, and two, your cougars are a nuisance. But the board didn't really have architectural approval authority, so that didn't matter. And the court held that the cougars were pets. So they said the owner won, the board lost by trying to stop them from having a cage outside with their cougars in it.
Yeah, I wonder what that did to the resale values of the neighboring properties if you had a cougar. Anyway, yeah, it's pretty interesting. Let's do our next poll. Okay. Okay, I'm gonna launch it. Here's the question. The Architectural Review Committee adopts a paint color guideline. The board doesn't agree with the ARC's brand new paint color guideline. Can the board override or overrule that new set of guidelines by the ARC? It's like the bulk are voting yes, the board can. Now, Bruce, if the answer to this is it depends on your governing documents, that's no fun.
Well, of course, it's always the answer.
I know, unfortunately, that is.
It
looks
does.
like, yeah.
It would depend on the CCNRs. But most of the time, from what I've seen, the authority to adopt ARC guidelines is conferred to the exclusive authority of the ARC. And when the CCNRs say that, even though the board usually has the authority to appoint and remove ARC members with or without cause, I don't interpret that as being that they can override or overrule a particular ARC guideline that's adopted by the committee. The only thing that the board can do is remove the members and appoint new members that they will hopefully adopt rules that the board agrees with.
Yeah, good.
That's typically the way I've seen CCNRs set up. Now, there may be the possibility that CCNRs could be written in a different way where the board would have that authority.
Listen, I already know there's a typo here. I didn't have anyone proofread these slides. I'm sorry. That's supposed to say assault. I don't even know if assault is a word. That's embarrassing. I actually, Bruce, I had Avery proofread and then I added this slide just after she looked at it. That's my bad. But there's some examples of unreasonable rules that could create a safety issue. And there's a couple of cases where the rule said that owners can't install exterior safety lights and that sort of thing. Someone gets assaulted or assaulted. And is there liability? Bruce, what do you think on that one? Let's say the rule says you can't have motion sensing lights on your front door and there's a break-in that could have arguably been prevented if there was a motion sensing light.
It's a loaded question. I know the case you're referring to, but the case you're referring to, it really wasn't about whether the rule itself was authorized or reasonable. It was a question of whether or not the board was liable in negligence for contributing to the damage that occurred by disallowing the lighting. And they were found, contributory negligent. So
Yeah.
Wow.
now would that per se mean that the rule is unreasonable? Probably, but that's just not what the case was about. So
there's also a case out of Hawaii where the board adopted a rule that said no owner can light candles inside of their unit. Now, the basis behind it, according to the board, was safety, right? They live in a high-rise condo. They don't want the risk of fire. But a court ultimately found that it was too overbroad, that it stepped over by prohibiting that. And then, of course, any rule that targets what are called protected classes are generally going to be invalid. Which leads me to our next poll. By the way, we only have 4 polls, so if you don't like these polls, I hope you do. There's only 2 more left. Let's say one night, board of directors of a condo decides to adopt adult-only swim hours. And it's not a 55+ community. It's got families with kids. Does that have the potential to violate the Federal Fair Housing Act because of discrimination based on familial status?
Definitely.
Now, the way this is phrased, the board can adopt anything, Whether they get sued about over it or whether it's valid is another question. I've seen boards adopt lots of stuff that they shouldn't. So what I mean to say is, if they do this, are they exposing themselves to legal liability?
Good poll, it's pretty evenly split.
It is. But still have some answers coming in. We'll let this run for a second. That is pretty even, Steven. We'll give it another 10 seconds, and then Bruce, I'll let you give your answer. So it looks like 20 yes, 17 no, 20 yes, 18 no. All right, I'll end the poll there. Bruce, what do you think?
Yeah, I'm pretty sure that that kind of a rule would violate the Fair Housing Act. I think courts have actually, this question has been before courts, and the courts have ruled that essentially that kind of a rule treats families with children different than families without children, and therefore is discriminatory based on familial status.
Yeah, that is based. There was I think it was in Florida where this was an actual case. Now, one exception, and I keep mentioning my dear friend Ken, federal and state law allows housing providers or HOAs to discriminate based on age in very specific circumstances, 55 plus communities, but there has to be language in the governing documents authorizing that and all of that. So that, keep that in mind. If Ken's board at King City wanted to do adult, that's fine because everyone there is an adult, right, Ken? I was going to say, hypothetically, let's say I lived in a 55 plus community, but then I know all of you would say, Kevin, that is crazy. You're not a day older than 30. And again, I can't tell if people are laughing or realize I'm trying to make a funny joke, but it's, yeah.
Kind of looks like the reaction that like a pretty bad.
Yeah.
Yes.
Judith, what are you nibbling on there? I think she said cheese. It looks yummy.
You've got a couple questions. Do you want to do them now?
Oh, yes, let's pull those up.
Okay.
We got a few. Okay.
Yeah, and I have one just to me.
Perfect. Okay, let's do the first one. This is from Cliff. If the declaration is publicly recorded, is it not, whose responsibility is it to know about them? Bruce?
Yeah, if it's recorded, typically the owner is what's on what's known as constructive notice or record notice, and so the law will typically deem that the owner knows of their content, whether they've actually read them or not.
That's right. Yeah, so a lot of times when we've sent letters to owners who are in violation of the CC&Rs, often their response initially is, "I never got them," or "I never read them." If they're properly recorded in the county recorder's office, like Bruce said, that's called record notice. You're deemed to be on notice, and you're bound by them. Jim, it looks like you probably typed this in response to a question, and I didn't see it, but Jim said, wouldn't it depend on what the CC&R said? But I'm not sure.
I think that was in response to our question about whether the board can overrule ARC guidelines.
Oh, yes. Yeah.
And
Good.
Jim was right.
Yep.
As
Now,
usual.
Kathy brought up a good point. What if the board in this poll, instead of adult only, did lap swim? Yeah. I don't see a problem with that. And when it comes to fair housing and discrimination, the liability is significant because intent doesn't matter. Very good people with not a discriminatory bone in their body can be liable under the Fair Housing Act because of something they did or said that had the effect of discrimination, even if they didn't mean to. And so I tell real estate agents, I tell board members, memorize the protected class and be aware and cognizant of the phrases and terms you use, and make sure that they don't have any connection to any of the protected classes. Let's see, what else? Oh, someone said we have senior swim and families aren't allowed in the pool. Yeah, that's problematic, in my opinion. Jennifer says, can you have hours for family swim and times for adult swim? I would avoid any type of swim that has kids or adult. Lap swim, I think, is fine to do lap swim and then open swim. Generally, kids don't like to lap swim. Believe it or not, when I was in high school, I worked at a athletic club, and in the summers I did pool maintenance, and I got to know a lot of lap swimmers. Usually older folks, they took lap swimming very seriously, and if you got in their lane, you would risk, those little floaty boards, they would sometimes smack kids on the head if a kid, got into their swimming lane. So anyway, lap swim I think is preferable, Jennifer.
All
Is that
right, Kevin.
assault?
Kevin,
Yes,
can I-
that is. Yes.
Can I ask a question?
Yeah.
Because it seems like that we're going in the opposite direction where adults, we don't happen to have a pool here, but as an adult that likes to swim, I don't want to be out swimming when their families are out there because you can't actually swim because the kids are just everywhere.
Yeah.
That it seems to discriminate against the adults who just want to enjoy the pool and actually get some exercise and swim. So it seems like it discriminates against the adults. And I know
Kind of reverse.
these
Yeah.
in reverse, right? So all of these laws are designed to protect different groups, but at the same time, to me, it seems like they do the opposite
Well,
by by restricting, in this case, adult swimmers who just want to lap swim.
well, yeah, do lap swim. Like, if there is a teenager that likes to lap swim, fine, but that would avoid kids floating around if it's lap swim. Yeah.
Kevin, can I give you my question?
Yes, please.
Okay, this is from John. Is an architectural committee allowed to deny an exterior modification request if the modification does not meet municipal code? The request meets current aesthetic guidelines and permits are not required, and specifically, it is a setback from the property line issue.
Bruce, I'm going to give this to you. I'm going to rephrase it and summarize it. So I think the question is, let's say board says that approval is contingent on meeting or complying with building code, and the CCNRs don't have any language about that. Is that, Bruce, is that how you understood it?
Yeah, I'm guessing that the question is implying that there's nothing in the CCNRs that says, all improvements have to meet city code. If that language is in there, and there are a number of CCNRs that do have that language in the CCNRs, then the answer would be, yeah, but obviously, yes, the Architectural Control Committee could deny it on that basis because it's a covenant in the CCNRs. Now, if it's not in the CCNRs and the application meets all of the other architectural guidelines and the covenants, it's a tough question. I think probably
Oh, hi.
come
I'm
down
in
to
a
the
Zoom. Everything
scope
okay?
of the ARC's discretion as it's articulated under the CCNRs, and sometimes it may have some language in the CCNRs about whether they're have to act in good faith, and you take into account the Valenti case. I don't know. It's a tough question. I would think probably they shouldn't. I don't think the HOA would enforce city code unless there's something in the CCNRs that says owners have to comply with city code.
And that you see that occasionally.
Yeah. No, I mean, I see a lot of CCNRs that have that.
Yeah. One last question. When a board passes a rule, when does it become effective? Immediately after 30 days? After owners have received notice and a copy of it. So if you mail it, I would do 3 days after mailing. If you're authorized to email stuff, as soon as you email it, but you can't enforce a rule that an owner doesn't have knowledge of. Now, sometimes boards will do a rule or regulation and say this shall be effective starting, and it will have an effective date. You're free to do that, but it can't be any earlier than when it's clear that the owners received a copy of it. Now, let's back up for a minute and talk about the authority. A lot of your governing documents have language that says the board can adopt rules, and it might say pertaining to what. Regardless of whether you're in Washington or Oregon, generally the statute is going to give you that authority. Like here for the Washington Homeowner Associations, says unless otherwise provided, association can adopt and amend bylaws, rules, and regulations. For Oregon planned communities, same thing, you can adopt bylaws, rules and regulations, condos. Now, in the Planned Community Act, and I put this in here to illustrate this concept, that the rules must be consistent with the CC&Rs. And I think I did that because there have been actually, I'd say about a dozen times over the years where I've seen boards adopt a rule that says no short-term rentals. But yet the CC&R say there shall be no restriction on an owner's ability to rent. My position is that rental restrictions, particularly in Oregon, must be in the recorded governing documents, that you cannot do that by rule unless you've got authority in the CC&Rs, or if in a condo in the bylaws. Now, Bruce, I'll kind of turn it over to you to talk about authority.
Yeah, so generally, and can you go back to that?
Oh, sorry.
So, a lot of associations come to us and they ask us, to look at their rules and let them know whether we think it's within, the board's authority to adopt without a vote of the membership, without an amendment of the documents. Generally speaking, we analyze it under this structure, which is that there's three types of authority. There's implied authority, there's specific authority, and there's general authority. And there needs to be at least one of these sources of authority in order for a rule to be obviously within the board's authority. So implied authority, you can go to the next slide, is essentially the authority that any association has simply because it is an association. It's implicit in the existence of that association. But courts will, you say that, implied authority isn't particularly broad. It only governs, gives the board authority to adopt certain kinds of rules. And those are typically rules governing the common property, rules intended to protect the common property, or in the other one that's not here, sort of administrative, or associate, I guess the last one, ensuring association can carry out its functions, but it's also sort of administrative and operational rules. But those are sort of implicit within the board's authority for any association. Now, general authority is any conferral of rulemaking authority that would be found in either the CC&Rs or a statute that is very broad and open-ended, is not specific to any particular subject matter. So, Kevin, can you back a few slides to the statute?
Yeah.
So this is a conferral of general authority. The association may adopt rules and regulations. It doesn't say about what, it's just very general. That authority is granted. And if you go back to the prior one in Washington, it's the same thing. It's a very general conferral of authority. And so in Oregon and Washington, whatever statute you're under, there's going to be this statutory general authority. Almost all CC&Rs or bylaws have them as well. So, then the question is, well, what does that extend to? And how far does that extend into regulating an owner's use of their unit or their individually owned lot? And courts will not construe that general conferral of authority as being extremely broad. That typically say that rulemaking authority will extend into the individually owned property to the extent that the rule is either intended to protect the common property, or that the rule is intended to prevent nuisance or nuisance-like behavior. So to the extent that the rule essentially prohibits one owner from unreasonably interfering with another owner's right to enjoyment of their own property. So under that general authority, a board could adopt a rule saying that you have, if you're going to smoke on your unit, you have to keep that smoke from going into your neighbor's unit. That would be, smoke going from your unit into a neighbor's unit would be a nuisance, and that's going to be something that a board generally has the authority to regulate, even though it's a rule that would govern what somebody does in their own property. Yeah, you got your hand up, Kevin?
Yeah, can a rule be more restrictive than a local ordinance? For example, let's say the county ordinance says any property owner in the county can have up to 3 chickens. And then let's just say the CC&Rs have rulemaking authority for any exterior improvement, and it says no chicken coops allowed. Is that okay? Because the county code says it's okay.
Absolutely, it can be more restrictive if it's within the board's authority. I don't, the fact that it's something a use is allowable under a local ordinance isn't going to mean that an association can't prevent that use.
Bruce, that's the correct answer.
Now, what's interesting though about local ordinances and nuisances is that many local ordinances, many municipalities will have ordinances that have declared some uses or activities to be a public nuisance. So for instance, I believe the city of Bend has an ordinance that says storing inoperable vehicles on your property is declared a public nuisance. And so my take is that that general rulemaking authority, and this is that first poll, would extend to preventing inoperable vehicles on the individually owned lots, because that has been declared a public nuisance, and that your general authority extends to nuisance and nuisance-like behavior. So then the third kind of authority is specific authority. And specific authority would be authority in your CC&Rs that confers to the board rulemaking authority over a particular subject matter. So for example, the board of directors may adopt reasonable parking rules. And if you have a language like that, so parking in the subdivision is subject to reasonable rules and regulations adopted by the board of directors. If you have that sort of specific conferral of authority, then within that subject matter, the board is going to have extremely broad authority to regulate that activity. So because essentially the owners are put on notice that they don't necessarily have a right to park, it's all subject to the discretion of the board of directors to adopt reasonable rules and regulations governing that activity. So that's sort of the rubric that we always look at when we try to figure out, is this particular rule something that the board could adopt as opposed to something that the owners would have to vote on. If it's a rule that is not either, within the board's implicit authority, their general authority, or their specific authority, then it's something that has to be an amendment to the CC&Rs and voted on by the owners.
And Bruce, do you see the question from Catherine?
I didn't. What is it?
It says if the CC&Rs only limit the duration of a rental, say owners can rent, but it must be at least 30 days. Can you do a rule that says, well, only a certain percentage of owners can rent?
I would say no. I would say that particular rule is, it's not enough to be sort of tangentially related to something that's in the CC&Rs. I think it has to be specifically authorized by the CC&Rs if it's not a nuisance like behavior that you're regulating.
And then Jennifer has a question. And actually, Jennifer, in just a little bit, I'm going to show you a rule regarding noise transmission between flooring. But Bruce, Jennifer's question is, can they adopt it? Would this apply to a rule adopted to require impact noise barriers to be installed under flooring when current flooring is replaced to limit the noise level?
Potentially, yeah. I mean, I could see that being within that implicit, that sort of general authority to prevent nuisances in terms of noise transmission between units, especially particularly in a condominium environment where noise transmission can really be a big issue.
Good. MR, we're all caught up on the questions, I think. Let's do our second to last poll. Oh, no, this is our last one, actually. All right, here's the question. The board wants to adopt a rule requiring owners to keep dogs. Oh, actually, hang on. That one is actually based on this case study that I read from Massachusetts, and I actually phrased it wrong, but here it is. So Massachusetts Condominium Association adopted a rule prohibiting pets from leaving their condominium units entirely. Two pet owners, Rhonda and William Dean, this meant sneaking their 70-pound dog into the car without letting its paws touch the hallway or the elevator, and then driving it outside the community to relieve itself. They sued, and a judge declared that the rule was unreasonable. Yeah, a rule, especially if there's no blanket pet prohibition, a rule that says the pet can't walk on the carpet is, I think, most likely going to be unreasonable. Would you agree, Bruce?
Well, the judge said so.
Yeah, I guess at the end of the day, it's whatever the judge says. All right, now let's talk about some of the practical things. And these are just based on our experience with helping associations draft rules. But the first question I always ask is why? Why do you want to adopt it? And generally there's good reasons. We want to preserve the aesthetics. We're having noise issues. This one owner's having parties. Fine. So identify the need. And then, as Bruce has been harping on, figure out what authority you have to adopt it. Bruce, pipe in.
Kevin, what's that third one there? Is it what's comments?
All right, I did not have these proofread, and I feel, you know what's funny? If you've ever received an email, there's a 99% chance that if there's no typos, I had someone in my office proofread, because even with spell check, I'm just and Bruce, you have no room to talk. Bruce is the king of typos.
I live by a
Hey.
do as I say, not as I do policy.
Kevin, I have a serious question.
Okay.
What's a doped non-number 5?
Yep, it looks like my fingers were,
A little overactive.
yeah.
So sorry, what did you want me to talk about?
I was just saying that identify the need and then identify your authority to adopt the rule, whether it's specific or general, as Bruce has been talking about. I recommend using committees anytime you can. It's a good way to offload work to other folks, especially if you have folks that are interested and willing to volunteer their time. Bruce has seen me do this at meetings where an owner stands up and complains over and over and over about whatever. I always tell the board chair, right here, right now, create a committee to address this topic and make recommendations to the board and appoint this complainer to head that committee. Sometimes that works, sometimes that backfires. But oftentimes
Backfires how?
the complaining, it does not calm that owner down. They just stir the fire. But I've seen lots of circumstances where the board wants to create policies or regulations with respect to art, and there's someone with experience in project management or construction. Use resources, especially if you have owners that are willing to give you their time and thoughts. Create a committee, have them make recommendations. One thing, and again, use your discretion. Sometimes it's wise to solicit owner feedback. And I say this particularly because I've been in situations where I've helped the board or worked with the board to draft language, and me and all of the board members read it and interpret it one way, but all of a sudden when the owners see it, they read it a very different way. And so I think that's a good way just to make sure that the language is clear, that the owners understand what it is you're trying to do. And I've seen associations have town hall meetings. What's the internet Survey Monkey? Bruce, haven't we had a bunch of folks use Survey Monkey to send out surveys to owners? And I think it's free for most folks. So that's another good way to solicit feedback on proposed rules. And then adoptee and distribute. Now, in terms of how the document should look, I'm a stickler for font size and lots of white space and easy to read documents whenever possible. And so the way I like to structure rules or policies or resolution is first cite to the authority, tell whoever's reading it what the purpose of it is, the scope and intent. And one of my biggest pet peeves, and lawyers love to do this, and board members recycle it because they think that if they use whereas, it makes it sound like it's a more important document for some reason. I think it's distracting and clunky, okay? Now, I'm going to show you a few examples and then we'll go back to enforcement. Yeah, don't look, whereas, I don't like that, okay? It's just stuffy. Now, here's a good one. This is just a construction access resolution or rule. So association obligated over, so we've stated their authority, we've stated the purpose, they've walked through what they're trying to accomplish. And this is just a little snippet of this rule. Here's another one. In this association, it's a condo association, and it does give specific rulemaking authority to the board of directors when owners want to modify their condominium. And so they've made two distinctions. If it's minor changes, board approval is not required for minor changes such as interior decorating, painting, papering. Now I'm guessing, based on the demographic of most of you folks, I bet half of you have wallpaper at your house.
Nope.
That was also supposed to be a joke. My grandma used to say only old people still use wallpaper, and that's why she kept it. But I don't know if that's true or not.
I'm in that.
It's coming back. Yeah, I was just watching a home remodeling show, and yeah, wallpaper is making a huge comeback. It's kind of interesting.
Yeah.
Now, I'm kind of proud of this one. This was, they wanted to adopt a rule or a resolution that outlined, based on the governing documents, who was responsible to maintain what. And all of these were sort of scattered throughout the governing document. So we just did a quick little chart as an exhibit that says this: if it's got a red box on the right, that means the unit owner has an obligation. And a lot of these instances, there's an overlap there, but everything else is associated. That's a quick, easy visual way to see maintenance responsibilities. Here's a schedule. I'm going to come back to this because we're going to talk about schedules of fines in just a moment. And we'll come back to that. Now let's go back to enforcement. Bruce, I'll turn it over to you for a moment to discuss what are the association's options when they have properly adopted a rule, they've got the authority, it's been distributed, and an owner violates it. What are the options the board has?
Well, the two that are standard are to levy fines and to seek injunctive relief. Now, injunctive relief essentially means that you file a lawsuit asking the court to order the owner to bring their property into compliance, or to
stop doing,
or to cease an activity that is a violation of the covenants. And the fine is obvious. It's a penalty, financial penalty for violation of the covenants. Those are generally available. The third one that you had up there was self-help. And self-help is often put into CC&Rs. And what that by self-help, what that means is oftentimes a CC&Rs will authorize the board of directors to enter into a lot owner's property or a unit and remedy a violation and then charge the cost back to that owner. And that is in a number of CC&Rs. It's not in any of the statutes that govern common interest developments. It is almost it's something I almost never recommend using.
Same.
The one basic simple reason is that in this country, a lot of people have guns, and you go on their property, who knows what they're going to do, and there's really no rule in any HOA that's worth risking anyone's life over. But there have been times where we've recommended using self-help. It'll be in situations where, say, it's an abandoned lot, or it's just sat empty, and now there's some safety issue there. In those situations, where there's almost no other resolution, sort of you can't really sue anyone because there's nobody there for the court to order, and levying a fine isn't going to get you anywhere because there's nobody in control of the property. Then in those situations, I have recommended that association resort to self-help, but it's very, very rare that I would recommend that.
So Bruce, walk through the fine process very clearly, because this is an issue that we deal with weekly.
Yeah. So in both Washington and Oregon, the statutory authority to levy fines states that the board may, after notice and an opportunity to be heard. Now, to be clear, it doesn't say opportunity for a hearing, it says opportunity to be heard. After notice and opportunity, levy reasonable fines in accordance with a previously adopted schedule of fines that has been distributed to all owners. So there's a lot of procedural requirements in that statement that a board has to meet before levying a fine against an owner. Those are really due process type of procedural requirements. Due process is a constitutional concept that doesn't typically apply to HOAs or condos because they're private organizations. They're not governed by the Constitution, which regulates government. But the statutes have essentially imposed some due process like protections for owners, and that's essentially before the fine can be levied, they have to be given notice of what the violation is, and they have to be given the opportunity to be heard prior to levying the fine.
Bruce, do you remember the fine letter we looked at today? And it's very nuanced, but it essentially said, you're in violation. We're levying a $50 fine. If you want to appeal it, let us know. That
Yeah,
doesn't work.
Yeah, and my take is that is not procedurally valid, that the opportunity to be heard has to be provided prior to levying the fine in the way the statutes are written.
Okay, two more questions for you, Bruce. One, talk about a schedule of fines, and two, let's say the association does levy all of these fines and the owner says, I'll just keep paying it, or doesn't pay it and keeps violating, then what?
The first question, talk about a schedule of fines. So schedule of fines is essentially the way in which owners receive notice of what the financial penalty will be if they violate the covenants. And essentially, because the statutes say that the schedule of fines has to be adopted and distributed to all owners prior to levying fines in accordance with it, it's essentially giving owners that right to know what the consequence will be before they're fined. Now, a schedule of fines can be, as complicated or as simple as the board, reasonably determines is appropriate. So this is actually this sample that's on the screen is a relatively detailed and more complicated one, where the specific violations are listed out, and you have different fine amounts for different types of violations. I've seen much simpler schedules of fines that'll just say any violation is $100 a month, or and it really can be set in the way that the board feels is appropriate. Now, the amounts have to be reasonable. Statute says they have to be reasonable. What's reasonable? Again, it's somewhat in the eye of the beholder, but in my opinion, reasonable means it has to be set an amount that will actually deter the behavior. The point of the fine is not to raise capital. It's to deter owners from violating the rules. And in order to figure out what's reasonable, I think the board has to take into account the financial wherewithal of the owners and the severity of the violation, and it has to set it at an amount that's going to be appropriate. I have seen associations levy fines for removal of trees in the tens of thousands of dollars. And it might seem like that, just on its face, like that is a staggering number. But in the context of an HOA where, the property values are $3 million, and, taking down these trees, which is prohibited by the CC&Rs, would open up a view that might be worth $100,000. The fine has to be substantial, or else an owner is simply going to say, I'll remove the tree and pay the fine.
Wasn't there one years ago, it was like Lone Pine subdivision named after this one lone pine tree in the middle of that had been around for 1,000 years. And so if you touch that, it was like $1 million fine or something like that. Not quite. But Bruce, sorry, I didn't mean to cut you off.
That's all right. That first part was talk generally about schedule. What was your second question?
My second
What happens
question
if the
is,
owner-
let's say you just keep fining. What are the association's options to collect those fines?
Well, the fine is an assessment, so legally it has the same legal effect as regular dues. So once it has been assessed, you can bring an action to collect that amount of money if they don't pay it. Also, the board also typically has, as a second option, a suit for injunctive release, asking a court order to order them to remedy the violation. But
do the fines constitute a lien on the owner's property?
they sure do.
So they could potentially foreclose on that lien.
That's true.
Okay. We've got just a couple minutes left. We'll wrap up with sort of the takeaway tips. Keep them simple. Tailor it to your community. Convey, a lot of times, and I usually say this when it comes to bylaw or CC&R amendments, drafting the language, that's pretty easy. The hard part is getting people to get on board and say yes. And so I always, when possible, convey the benefit and the need for the adoption of the rule. That goes a long ways with helping owners understand the purpose and wanting to, and complying with it. provide some flexibility in certain circumstances, giving some discretion. And again, make sure that you can show that the owners receive notice of these unrecorded rules, regulations, and resolutions. And with that, folks, next month, oh, folks, if you like this, buckle up. Next month is my favorite topic ever, which is running meetings and parliamentary procedure. I may have done this one the end of last year, so I think a couple of you may have seen that one. Doesn't hurt for a refresher, but boy, do I get excited when it comes to Robert's Rules of Order. In fact, I just ordered 4 new copies of the latest edition. They're sitting right out here on the bookshelf. Well, questions, comments, feedback? Did you all learn something today, hopefully? Yes, you got a thumbs up there. Good, good, good. Well, thank you. These are a lot of fun for us. Bruce and I, usually a week, sometimes up to 2 weeks before we even do these, we start talking about how what we want to focus on. And we try to tailor them to, especially if, a lot of our association clients are having similar issues, we try to focus on things that are of relevance to all of you. And always hope these are good learning experiences for you, and keep it. Yeah. And again, we just have fun doing these. They're a lot of fun. And one day we'll do some in-person ones, and I'll have treats, pastries, coffee, tea. That's my favorite part of seminars, is the food that it usually comes along with it. And so that is one drawback of these Zoom ones. But anyway, yes. Oh, thank you, Bruce. Oh, Catherine asked, so the new Community Association handbook is almost there. It will be ready for purchase, I'm hoping, in about 30 days. It's getting there.
He's been hoping it to be about 30 days.
No,
for
I have been
3
saying that
years
for
now.
years. I know, I know. It's almost there. Well, thank you, everyone. And I hope you have a lovely evening. And I hope we see you next month at board training. Take care.
Good night,
Thank you.
everyone.
Good night.